Good afternoon, everybody, and thank you very much for joining us today for our webinar on lobbying and what compliance professionals need to know. My name is Fiona Hanlon, and I'm part of the Compliance Institute exec team. So as always, the webinar will run for approximately 1 hour, and we will leave time at the end for Q&A. So please submit your questions there in the Q&A function or through the chat function, and we'll address them at the end. The CPD code is 2025-2566. And I'll send that to all attendees along with a copy of the slides once the session concludes. And if there's anything you want to recap on today, the recording will be saved in our library section of compliance.ie later on. So I'll hand you over to our speaker for today, Mary Alice Cleary, who's a partner in the Dispute Resolution and Litigation Department in McCann Fitzgerald LLP. Thank you.
Thank you very much, Fiona, and good afternoon, everyone. So as Fiona mentioned, I'm a partner in McCann Fitzgerald, and I specialise in regulatory law, lobbying, consumer protection, and financial services. And so today we're talking about lobbying, which is quite topical given that the scope of lobbying laws increased this year. However, more fundamentally, given the prevalence of lobbying and the potential criminal penalties where lobbying laws are not complied with, it really is an area that compliance professionals need to be alive to, so that you can flag internally what does and does not constitute lobbying and the legal obligations consequent on lobbying. So I'll begin by briefly recapping on the rationale for lobbying and its regulation. I'll then examine the requirements of the Regulation of Lobbying Act 2015. Next, I'll provide some compliance tips, and then I'll finish by looking at the penalties where breaches occur. So the first point to remember is that lobbying is generally a good thing, as it plays an important role in policy formation. And as Minister Howlin, the architect of the Regulation of Lobbying Act, put it, lobbying is absolutely necessary in order to maintain a healthy and well-functioning democracy. Neither government nor the public service has a monopoly on wisdom. We cannot operate in a vacuum. We need to hear the perspectives of all sectors in order to make sound, well-informed decisions which best serve the needs of society as a whole. So fundamentally, the purpose of the Act is to make lobbying more transparent rather than to inhibit it in any way. As Mr. Howlin said, the purpose is to provide for a web-based register of lobbying to make information available to the public on the identity of those communicating with designated public officials on specific policy, legislative matters, or prospective decisions. So before examining the Act in detail, I think it's helpful to frame the discussion by outlining some of the key points at the outset. So the key requirement of the Act is that persons carrying on lobbying activities must register as a lobbyist, and they must make returns every 4 months detailing their lobbying activities. So you can go on to lobbying.ie, and you can access both the Register of Lobbyists, which as of the end of 2024 had 2,710 individuals or organizations registered. And you can also access the Register of Returns that have been made. And for example, over the course of 2024, over 12,000 returns were made. The Act also provides for a 1-year cooling off period during which lobbying may not be carried out by certain former designated public officials unless consent is obtained from the Standards in Public Office Commission, or SIPO, which is the lobbying regulator. So what is lobbying? Well, a person is regarded as carrying on lobbying activities if they fall within the scope of the Act, they make, manage, or direct the making of relevant communication other than accepted communications, either directly or indirectly to a DPO in relation to a relevant matter. So when I get a query as to whether a particular communications constitutes lobbying, I will go through each of these requirements and see whether they are applicable. And I'll look briefly at each of them now. So the first requirement is that a person comes within the scope of the Act and that they make, manage, or direct the making of a relevant communication. So who is within the scope of the Act? Well, pretty much most entities. So you have a person with more than 10 full-time employees. You have representative bodies which exists to represent the interests of its members and have at least one full-time employee. So these are your trade unions, your professional bodies, your industry associations, or your sporting bodies. You then have advocacy bodies, and these are organizations which exist to take up particular issues and has at least one full-time employee. So for example, organizations that are set up to promote the arts. You then have a representative or an advocacy body which has no full-time employees, but so it's voluntary, but where at least one of its members fall within the preceding three categories. The next category of person is a person making a relevant communication on behalf of a person within one of the categories above in return for payment. So this is generally referred to as the professional lobbyist category. But, you know, depending on the circumstances, it could include solicitors, it could include accountants or other people making representations in return for payment. And the final category of person is where a person makes a relevant communication concerning the development or zoning of land, which is not their principal private residence. So if you're making representations in relation to a second home, to a DPO, then you fall within the scope of the Act. So in summary, there's very few entities that do not fall within the scope of the Act. One example would be a small company that has less than 10 employees and where the relevant communication does not concern the development or zoning of land. So listed on the slide, I've just included some of the organizations which are most actively lobbying in the area of banking and financial institutions. So you can see that in terms of the scope of persons we've just discussed, you have the representative bodies. For example, you've got the Banking and Payments Federation of Ireland, you have Insurance Ireland, and then you have other bodies that have more than 10 employees and therefore fall within the scope. So the various financial institutions listed there. And the register is very accessible and searchable, so you can easily find out who is doing what and with what public officials. And that's the whole point behind the lobbying regulation, is just to make everything transparent. And so a recent example of a huge lobbying campaign was in the hospitality industry. And you'll have seen the Restaurant Association of Ireland put in a huge campaign to secure a reduction in VAT at the time of the last budget. And so you can see that they registered all their returns. And so it was a very effective lobbying campaign, but it was also very transparent, and they have a huge amount of returns on the lobbying register. And I've just included some of them there. And you can see that the information given is that they're making communications in relation to price of doing business. And this doesn't even include the pre-budget period. So if a communication is an accepted communication, then it does not constitute lobbying. There are 16 types of communications which have been designated as accepted communications, and I've included some of the more relevant exceptions on the slide. So for example, communications by or on behalf of an individual relating to his or her private affairs. However, communications relating to the development or zoning of land are not exempt unless they relate to your principal private residence. Secondly, you have communications requesting financial information or providing financial information in response to a request for information from a DPO. So for example, if you query the planning rules, that's you requesting factual information, and that is accepted. Or if a representative body that is within the scope of the Act provides information to a DPO, so for example, the Secretary General of one of the government departments, in response to a request from that Secretary General, then that is accepted. Next, you have communications by a public service body and published by it, or sorry, communications requested by a public service body and published by it. So for example, if a public service body requests submissions on on a particular topic, you make those submissions, and then those submissions are subsequently published by that body, then that is an accepted communication. Why? Because transparency has been achieved because your submissions have been published. Next, you have communications by a DPO in his or her capacity as such. So if you are, say you're the governor of the central bank, you're a designated public official. If you're communicating in that capacity with the Minister for Finance, then that is an accepted communication. Similarly, communications made by a person employed by a public service body and which relates to the function of that public service body is also accepted. So you may not be the DPO, but you might be an employee of the public service body. And if you're communicating relating to those functions, that is accepted. And the final one is communications by a body corporate to a minister who holds shares in it or who has statutory functions in relation to it, or to a DPO serving in the minister's department in the ordinary course of business of the body corporate. So this exception kind of relates to commercial state bodies. So for example, if there's communications between somebody in CIE and the Minister for Transport in the ordinary course of business of CIE, then that would be accepted. SIPO say that it's a matter for the body corporate itself to decide what is and is not in its ordinary course of business, but then they do go on to give some examples. So for example, they say that a progress report by the commercial state body would be considered to be in the ordinary course of business, whereas if the commercial state body was, requesting additional funding or seeking legislative change or additional powers, then that might not. So the next requirement is that the communication is made either directly or indirectly to a designated public official. So who are these designated public officials? So you have the obvious ones, the ministers and the ministers of state, the TDs and senators, MEPs for Irish constituencies, members of local authorities, and special advisors to ministers and ministers of state. And then you have this whole separate category, which is public servants as prescribed. And the minister has prescribed by way of statutory instrument a couple of hundred of public servants as DPOs over the last 10 years since the Act was enacted. And these include senior officials in the various government departments, local authorities, and public service bodies. The most recent SI took effect at the beginning of this year and prescribed 180 senior officials across 62 public service bodies, including the CBI, the CCPC, Coimisiún na Meán, and the Corporate Enforcement Authority as DPOs. So communications with these people could now constitute lobbying, whereas last year it wasn't. And so this implements a programme for government, a commitment to enhance transparency by expanding the scope of lobbying to include senior officials in public bodies which have significant policy making or development functions. The list of prescribed public servants is very, very broad and includes a couple of random positions, such as the senior petroleum specialist in the Department of Energy. And so when a question as to lobbying arises, I would encourage you to take a look at the 4 SIs that have been enacted and to see what public servants have actually been prescribed. And so one of the questions that has been submitted in advance is, what kinds of interactions could constitute lobbying? And I think the first point to remember is that formality doesn't matter. It can be a casual conversation. It could be a tweet sent to a DPO, or it could be a tweet in which a DPO is tagged. All of these count as lobbying. Similarly, if you're making a speech in a room full of people, and if a DPO happens to be in the audience, that is not lobbying. Whereas say if you specifically called out a DPO and directed the message at them specifically, then that could be veering into the territory of lobbying. In addition, indirect communications with DPOs are captured. And so an example of this is where a person is communicating on a relevant matter with a public official who is not a DPO, and the person requests or indicates that the communication should be brought to the attention of a DPO, then that is indirect lobbying and therefore falls within the scope. But if, on the other hand, you're communicating with somebody who is not a DPO and you don't say anything further about what is to be done with that information, and that person then of their own volition decides that they're going to bring it to the attention of a DPO, then that's not lobbying. You didn't ask them to do it. You can have no knowledge that that's what they're going to do, and therefore you can't actually file a return, and it's not in your control. So that's not lobbying. The final requirement is that the communication is in relation to a relevant matter, which is any matter relating to the initiation, development, or modification of any public policy or programme. So, for example, proposals for changes in taxation policy. And this is referred to as the public policy ground. Or the preparation or amendment of any law, including secondary legislation such as SIs and bylaws, and this is generally referred to as the legislation ground. Or the award of any grant, loan, or other financial support, contract, or other agreement, or of any license or other authorization involving public funds. And this is generally referred to as a matter involving public funds ground. Apart from any matter relating to the implementation of such policy, program, enactment, or award, or any matter of a technical nature. So often clients will say to me, I'm not lobbying because I'm not advocating for a change of law. I may be writing in relation to a change, but I'm not advocating for a particular position. But this is not necessarily an agreement of lobbying, as the definition refers to communications relating to a change in policy and not communications advocating for a change of policy. And indeed, in many regulatory frameworks in other jurisdictions, they specifically define lobbying as communications for the purpose of influencing policy, whereas ours does not. It refers to communications relating to amendments. So I think it's quite broad. And so a question was submitted in advance in relation to what activities are often not reported as lobbying activities and which should be. And I think this is a prime example. I don't think there's a general awareness of the breadth of the scope of lobbying, and that, even though you might be advocating for a change or advocating for the introduction of a law, communications in relation to it, depending on the circumstances, could still constitute lobbying. So the definition is quite broad, but it is tempered by this reference to implementation and technical matters. And unhelpfully, these aren't defined in the Act. And there has actually been no case law on any provisions of the 2015 Act to aid with the interpretation of its various provisions, which is also a point to be borne in mind. So an example of a relevant matter is communications regarding a proposed policy to reduce motor emissions. But if the government consults with scientific experts on the level of emissions that may cause harm to the environment, that would probably be a technical matter. Similarly, when the legislation is in place and a DPO receives queries concerning how do I conform with these new requirements, that would be regarded as a technical or an implementation matter. So the key point is that a person cannot carry on lobbying activities unless they are registered on the register, and thereafter they're referred to as a registered person. The prohibition does not apply to persons lobbying for the first time, so long as they register within 21 days of their first lobbying period. Lobbyists must then make returns every 4 months within 21 days of the last day of April, August, and December, detailing the lobbying carried out during the preceding 4 months, or where there has been none, and they must submit a nil return. When making these returns, it should be one return per subject matter rather than one return per communication. So if you're completing a lobbying return, all activities in support of the same subject matter should be contained in one single return. This means that you should include all emails, all phone calls, all meetings into the same return where they relate to the same subject matter. And the final point, which is important, is that if for whatever reason you do not think that your organization will be carrying out lobbying into the future, then you should notify SAIPO that you have ceased lobbying. And once you do that, you're no longer obligated to make returns. And so it is kind of annoying having to make nil returns and to remember to do so. So if you think you're done lobbying, then you should just notify SAIPO of same. So this is a lobbying return, and you can see that it's very high level in terms of its content, but it must include certain information. So you have to include the name of the lobbying organization. So here it's Teneo. You then have to give details of the subject matter of the communications and the results that they were intended to secure. So you need to select the relevant matter. So does it relate to public policy? Does it relate to legislation? Does it involve public funds, or does it relate to the development or zoning of land? Then you have to pick the policy area. So for example, here it's transport. You then have to include specific details of the communication. So for example, what policy or what legislation are you communicating in relation to? And then you have to include the intended results of the communication. So for example, are you looking to reduce tariffs, or are you looking for increased funding through grants? And SAIPO really emphasized that they don't want a very generic intended results bit. You know, it can't just be, I generally want to communicate my view. It has to be specific to what you actually want to achieve from the communication. So next, you need to include the name of the individual who had primary responsibility for carrying on the lobbying. And crucially, this may not be the person who actually conducted the lobbying activity, but it may be the person who instructed it to take place or who led the lobbying activity or the campaign. Next, you have to include the name of any designated public official that's employed by the registered person and who was engaged in the lobbying activities. Here, that wasn't applicable. And the next section is whether you managed or directed a grassroots campaign. So this is essentially where an organization, typically a representative body or an advocacy body, may issue an instruction to its members to lobby their public representatives or other designated public officials on a particular matter. And this is called a grassroots communication because it's made at grassroots level. However, it's the body directing the communication rather than the members actually making the communication that has the responsibility to register and submit returns for the lobbying activity. So what the representative body would be registering is the direction that they have issued to its members. And you don't have to give any further details about what actually happened thereafter. You then have to indicate whether the communications were made on behalf of another person. So for example, a client, and include information relating to that client. So here, Teneo, we're doing it on behalf of a client and they've included the relevant details. And then you actually give details of the type and the extent of the lobbying activities. So you have to specify, for example, whether the communication was by way of a letter or was it a meeting, how many letters, how many meetings were there, who were they sent to, and who were the meetings with. And then you have to specify the name of the designated public official that you met with or that you corresponded with, and the body by which they are employed. And then the final point to just note is that at the extreme top right of the return, you can see that there's an option for reporting inaccurate information. And so essentially, and this probably generally applies to the designated public officials. So if you are looking at a return and you think that, oh, it actually contains false or misleading information or inaccurate information, then you can contact SIPO and get them to rectify the situation and report it. And so if SIPO considered that the return requires further information or is misleading or inaccurate, it can then request the person who has made the return to rectify it within 21 days. If the person doesn't rectify it, then SIPO must remove the return from the register. And then it's treated as if the return has never been made. And therefore the person is in breach of their obligations because they've engaged in relevant communication, but they haven't made the return. So over the course of 2024, SIPO made almost 1,000 requests for further information, which the relevant entities did provide. And so SIPO didn't have to go ahead and remove any returns on this ground. So I think that's a point that DPOs should be conscious of. And the SIPO include guidance on their website for designated public officials. And part of the guidance is that designated public officials should keep an eye on, they should keep a record potentially of meetings they have so that they can go off and check whether the returns that have been made are accurate. So you'll have seen that the information contained in the return, while generally high level, it can prompt further queries from the public. It can prompt media publicity, or it can prompt FOI requests. And so that just is a point to be conscious of, that the return is high level, but if the media sees something of interest in it, they will likely pursue it further. And so here I've just included some of the areas being lobbied in 2024. So health is an area, the subject of a lot of lobbying activities, followed then by economic development and industry. And I think that's reflective of previous years as well. So I'm just mentioning the code of conduct for lobbyists because it's specifically referred to in the Act, and the Act provides that persons carrying on lobbying activities shall have regard to the code of conduct. And it's very straightforward, and it kind of goes without saying. So you demonstrate respect for public bodies, you act with honesty and integrity, you ensure the information you give DPOs is correct, you disclose who you are and why you're lobbying, you maintain confidentiality of information received, you avoid improper influence, and you observe the provisions of the Act. So again, all common sense stuff, but I just referenced it because it's specifically an obligation under the Act. On lobbying.ie, you can find a whole host of materials that are relevant to both people who engage in lobbying and also designated public officials. So for lobbyists, there's guidelines for lobbyists, there's kind of short information, kind of 3 paragraphs, what is lobbying. There's also an FAQ section, which is very helpful. And so I'd encourage you to take a look at those. There's lots of information on it. And then, as I just mentioned, for designated public officials, there's guidance for them in relation to their obligations. But the vast 99% of the obligations rest on lobbyists as opposed to designated public officials. So I think Obviously, this is the Compliance Institute, and you're wondering, what has to be done to make sure you're compliant with lobbying obligations. And I think the first thing to be done, if not done already, is that arrangements need to be put in place to record lobbying activities. So you need to figure out who in your organization is responsible for lobbying on behalf of the organization. You should ensure that everyone who lobbies keeps a record of their lobbying activities. And there is a good feature on the returns register where you can enter data on the register on an ongoing basis by more than one employee and save it in draft form in a private area that can't be accessed. And that can be done on a rolling basis. And then when it comes to the time for submission, a compliance officer should be appointed who has responsibility for looking at all those drafts and reviewing them and ensuring that they meet the requirements of the Act, and then submitting all the returns on behalf of the organisation. So there's a bit of prep work to get the process in place in the first instance. If you're carrying out lobbying for the first time, then you should register as soon as you do this. You need to make sure that you are aware of the reporting periods and deadlines. So they are done, as I said, 3 times a year, and you need to make your returns within 21 days of the end of the reporting period. And so these should just be off the bat put in your calendars. And then what is generally done is that the compliance function will email the relevant personnel who may have been engaged in lobbying or possibly could have been, or who has responsibility for it, in advance of the deadline to check whether any lobbying has been engaged with, or whether the person is unsure as to whether lobbying has engaged with and they want to discuss it further. So one of the questions submitted was how much responsibility and accountability is on the compliance function in terms of oversight and identifying issues. And I think the key role of compliance is, at the outset, communicating what is and is not lobbying, because I think there is a bit of a misconception out there as to what precisely it is. You then need to communicate what are the obligations consequent on lobbying. You need to figure out who the key personnel in the organisation are that would be likely to engage in lobbying. You need to send the emails in advance of the deadline, querying whether anyone has engaged in lobbying, and then review and submit these returns. Obviously, if having done all of that, and somebody doesn't disclose to you that they have engaged in lobbying, then there's really nothing more that you as a compliance function can do. The onus is on the person to tell you this so you can make the returns. So the Act includes a cooling off period for certain DPOs, and these are ministers, special advisors, and that big category of prescribed public servants. And the purpose of this is to manage the potential for conflicts of interest between the public and private sectors, and to place restrictions on the so-called revolving door, and essentially kind of to prevent the use of insider information. And so it's a safeguard intended to ensure that private entities do not gain unfair advantage from the knowledge or the connections or the network they had when they were a DPO. Accordingly, certain DPOs cannot carry on specific lobbying activities or be employed by or provide services to a person carrying on such lobbying activities during a period of 1 year after they cease to be a DPO without the consent of SIPO. So this restriction only applies where the lobbying involves any public service body which employed the DPO in the year prior to ceasing to be a DPO, or is to a person who was also a DPO employed by that public service body during that period. In essence, therefore, if someone is a special advisor in the Department of Finance, the lobbying cannot involve the Department of Finance. or it cannot be to a DPO who was in the Department of Finance at the same time as the person now lobbying was in the Department of Finance. The designated public official can, however, apply for consent from SIPO for a waiver prior to taking up such employment. And just one point to bear in mind is that while a prospective employer may not be carrying on lobbying activities when a person is considering accepting a job offer, if there's a risk that this could change into the future during the cooling off 1 year period, then the person should seek SIPO's consent prior to accepting the job. Because obviously if they started lobbying at a later stage, you would then be in breach of your cooling off period, having not obtained the SIPO's consent. SIPO can give consent either unconditionally or conditionally, or they can refuse it. And either a refusal or consent with conditions can be appealed. So if your organization is seeking to employ one of these designated public officials who are subject to these provisions, being the ministers, being the prescribed public servants, you should ensure that they have sought the consent of SIPO. SIPO have prepared a guidance note on the cooling off period, which sets out a number of factors which they will consider when looking at an application for consent. And I've included a sample of these on the slide. So over the course of 2024, there were 6 applications made, and these were all from special advisors to ministers. It's not made publicly available whether or not they were granted, but certainly I know anecdotally that certain of them certainly were. And SIPO, as a general position, say that they will only grant consent in exceptional circumstances. So they're going to look at whether the person was recruited by way of a competitive process or were they headhunted. So obviously, if you are headhunted for a particular position, that's going to count against you. They'll then look at the amount of the cooling off period which has passed. So if you have 11.5 months left, that's going to count against you, whereas if you only have 6 weeks left, then they might be less demanding there. They're then going to look at whether, when, and the extent to which the applicant or the former employer has previously been lobbied by the prospective employer. So if there has been engagements in the past, they'll take account of that. And then they'll look at whether and what extent the prospective employer intends to lobby the former employer in the future, or intends for the applicant, his or herself, to lobby. So they'll look at the future. What's the plan for the remainder of the cooling off period? So as I mentioned at the outset, one of the key points to be borne in mind is that a breach of lobbying law is an offence, and it can give rise to imprisonment. However, enforcement to date hasn't been huge. It has focused on the failure to make lobbying returns, and there has only been 1 conviction to date, though 2 prosecutions were initiated in 2024 and are ongoing. And in addition to that, there are also 3 investigations ongoing. Less severe is that over the course of 2024, 404 fixed payment notices were issued. So you can see that you can be guilty of an offence and liable on summary conviction to a fine of €2,500, or on indictment to a fine or imprisonment for up to 2 years or both, for carrying on lobbying activities without registering, failing to make a lobbying return, failing to comply with a requirement of an authorised officer, obstructing an investigation, or taking any action that has the intended purpose of avoidance or circumvention of an obligation to register or make a return. Then there's a less significant penalty, so you can be guilty of an offence and liable on summary conviction to a fine of up to 2,500 or a fixed payment notice of €200 for filing a late return. And you'll have seen, I just mentioned there, that there's been a huge amount of fixed payment notices issued all over the years, and that's for when you miss the deadline and you file late, but you do ultimately file it. And then the final sanction is whereby SAIPO can impose a minor or major sanction for when the DPO breaches the cooling off period obligations, or when any action is taken which has the purpose of avoidance or circumvention of an obligation to register or make a return. So it's kind of interesting. You'll notice that a breach of the cooling off period by a DPO gives rise to these administrative sanctions, whereas all the other breaches give rise to criminal prosecutions. And this was a real point of contention between SAIPO and the government when the legislation was being amended to introduce penalties for breaching the cooling off period. So SAIPO didn't want to have responsibility for imposing these sanctions, and they argued sanctions, that given the sanctions would anyway be appealed to the courts, that they should just be dealt with in the same way as all the other breaches, and therefore be dealt with by way of an offence. But this was rejected by the government, and they said that, you know, dealing with it as a criminal matter could have a chilling effect. So there's just this interesting divergence in approach. So lobbyists can be subject to criminal offences, whereas breaches by DPOs do not give rise to criminal offences. They are subject to this administrative sanctions regime. So what is a minor sanction? This means advice, a reprimand, a caution, or a combination of these. So quite minor, as the name suggests. Or a major sanction means a financial sanction of up to €25,000, or the prohibition on the person from registering on the register for a period of up to 2 years, or both. So to date, there has been no guidance on when SAIPO might impose a minor or a major sanction. But when determining the amount of a financial sanction to be imposed, they're going to look at the circumstances of the contravention, whether it's appropriate or proportionate. So that kind of, it's really the seriousness of the issue. And then if SAIPO does impose a major sanction, then that has to be confirmed by the circuit court. So there is some level of court oversight on these sanctions that can be imposed by SAIPO. So I think the key points to bear in mind is that the definition of lobbying is very broad. It's probably much broader than what people think lobbying is, but there are many exceptions. And when you're looking at whether something is lobbying, you need to go through each of the steps that I've outlined and figure out whether or not they apply. The most common issue that arises is where an entity fails to make a return, and there is a risk of criminal prosecution for breaches, though, as I've stated, there has only been one conviction to date. Like, part of the issue is it is very difficult for SAIPO to detect where unreported lobbying is taking place. So that's, you know, just a relevant point. So lobbying returns, although high level, they do attract a lot of media publicity, they do attract queries, and they do attract FOI requests. So that's just something that needs to be flagged internally, that, you know, while not a lot of information is disclosed on the register, it could well prompt questions. So you just need to be prepared when you're making that return that there could be further requests coming in relation to it. And then kind of like, so what will often happen in my job is I will get a request from a client and they'll say, I want to send this letter to the department. Is this lobbying? And so I'll take a look at it. I'll go through each of the steps. I'll flag that, you know, it either is or is not lobbying, and what the implications of that are. But there's also steps that you can take to remove it from the ambit of lobbying. So like one of the first things I'll say is, well, does the letter have to, do you want to send the letter to a designated public official, or can it be sent to somebody else in the organization? And if it is sent to somebody else in the organization who is not a DPO, then automatically that is not lobbying. So there's certain things that take it outside the scope. And then you just need to generally create awareness in your organization as to what is lobbying. And so, training of people who are engaged with the government departments, with public service bodies in relation to what is lobbying and what their obligations are, as well as compliance function, is pretty critical. So one of the questions that was submitted in advance is, what's the best approach for delivering lobbying training? And so I think you essentially just need to get all the relevant people in the room, so those who have potential to be engaged in lobbying, together with the compliance function, explain what lobbying is and what obligations it triggers, and then agree a process for ensuring that the organisation files all the necessary returns every 3 months. We in McCann Fitzgerald often provide this training, and we can then answer everybody's questions and everyone's on the same page. And in my experience, companies just find it very worthwhile to do every couple of years, and so it's something that might be worth considering on your end. That's it. Thank you very much for your attention, and I'd be happy to take any questions.
Thank you very much, Mary Alice, and thank you to everybody who has submitted the questions in advance, and for Mary Alice for addressing them. So we do have time there for some questions, so please do submit it through the Q&A function and we will address them as they come through. So there's a few submitted there already, Mary Alice, so I'll just open these up. Okay, so the first one there is, what are the most common compliance pitfalls organisations face when registering or submitting lobbying returns under the regulation of the Lobbying Act?
Yeah, so like a common issue is that your return is incomplete or contains insufficient information. And generally that won't be, you'll generally be given an opportunity to rectify that. So the SIPO will review every return and they will determine whether it contains adequate information. If it doesn't, they will go back to you and they will ask you to redo the return within a certain period. If you do that, that's all fine and that's the end of it. And if you don't, then the return can be taken down. It's then treated as never having been made, and therefore you're in breach. And that's going to give rise to issues.
Thank you. And the next one submitted there is, how can compliance officers integrate the code of conduct for lobbyists into existing ethics or integrity frameworks within their organization?
Well, I think I would think the code of conduct, like when you read it, it's just a couple of pages long. And I would think, it fits within current frameworks. So, like one of the grounds is essentially don't bribe public officials, which, is obviously clear from other frameworks available. So I think if you actually look at the code, there wouldn't be a huge amount that would be additional to existing frameworks that you would already have in place. So it would be more kind of integrating a process for ensuring your returns are made, as opposed to the code of conduct. So I think you just need to circulate a code of conduct, make sure everybody is aware of it, given that the Act requires them to have regard to it. But I don't think it will prompt huge fundamental changes within an organization.
Thank you. And the next one there is in relation to submitting a return. So should the return include board members or just employees?
So it can include board. So is this if the person who has been engaged in lobbying?
They haven't stated? That was just the main question that came through. Apologies, unless they want to.
So I can answer both scenarios.
Great.
So if the employee of an organization or somebody who holds a function in relation to an organization, so for example, if they're on the board, then that triggers the requirement to make a lobbying return, so long as they meet all of the other requirements. And the person who is specified on the return is the person who is deemed to be responsible for the particular lobbying activity. So that could change depending on the relevant communications. So there is, the Act actually provides a specific provision that the minister in the future can require that the person who actually carries out the lobbying activity is specified on the form, but for now it currently just says that it's the person responsible. So yeah, so it's either of those who engage in it are caught, but the person who makes the actual return can be the compliance function feeding in the information in relation to the lobbying.
They're flying in now, Mary Alice. So the next one there is, what practical steps can organisations take to ensure lobby activity is properly tracked and recorded across multiple departments or subsidiaries?
Yeah, so like it is difficult because, you know, some organisations are very large, and so I think you just need to get a process in place at the beginning to figure out who in the various functions will have engagement with public service bodies or with the government, and then agree with them the process. So you need to figure out who's going to be lobbying, and then you need to agree a process that they are going to send you the lobbying returns under the function. Like you could set up an Excel spreadsheet that contains the various headings that need to be completed, and send that around to people along with your email advance of the filing deadlines to say, has anyone been engaged in lobbying? And if so, please complete this, or if unsure, please talk to me. Or you can grant access to the draft section on the lobbying register where returns can be completed in draft, which you can then review to ensure that they fulfill the requirements of the Act. But it is tricky in the larger organisations, but I think a bit of a lift has to be done at the beginning to identify who the key relevant functions are and take it from there.
Thank you. Following on to that, I suppose this next question is in relation to over-reporting. So, for example, reporting lobbying adjacent activities that arguably isn't under the definition of lobbying. For example, lobbying by staff or firm, but not on behalf of the firm or its clients.
Yeah, so that is an interesting one, because obviously the example I gave is lobbying can be very casual, and it could be if you're down at the pub with a friend who happens to be a designated public official, but you're only captured by lobbying if you're down at the pub with your friend discussing changes to law in your capacity as an employee in your particular firm. If you're just down there in a personal capacity, that is not lobbying. And so it's not encouraged to make returns where they're not fall within the scope. And in fact, I've done presentations in the past with designated public officials, and they have indicated that, you know, when they looked at the returns on the register, that meetings were indicated that they had never met these people. And so there definitely is an approach where people kind of make returns out of an abundance of caution. But it was just interesting to note with this particular person I spoke to, he was like, I never met any of these. And he said that because they were fairly innocuous meetings with you know, bodies he might have met on other occasions, he didn't seek a correction. But for example, if there is particular bodies that if you're, you know, in the Department of Health and there's particular bodies that you mightn't want to be associated with, and then you would be seeking correction of that where the lobbying actually didn't occur.
Thank you very much. So that is all the questions that have been submitted. So thank you to everybody who has submitted them in advance, and obviously Mary-Alice for addressing them, and for everybody who has submitted the questions there at the end. As I'm sure everybody agrees, it was a very interesting webinar, so thank you so much. So as always, the CPD code will be sent to you shortly. It's 2025-2566, and a copy of the slides that we went through today will also be sent. So I'll close off by thanking everybody for joining today, and also to Mary-Alice Cleary for a really insightful and excellent presentation. So enjoy your day, everybody. Thank you.
Thanks, everyone.